I don't want you to answer the question. What I'm trying to break through to you is that I have repeatedly told you not to use.
So our hope was that he was able to make bond because it is reasonable. It's a reasonable amount of money, but the bond company won't bond him out without.
But even Mr. Brooker, even if you bond out, if you continue to make the bad choices, you're going to end up right back here over and over and over. You know, he's telling me that you want to plead guilty just to get out. I'm not going to do that because I'm not going to let you ruin your life. Because when you end up with these assault convictions, you're all but ruined. You know, do you think people hire assault convictions? You think you're going to get a job? You think you want to go to school to study this and that? It's all for naught, because when you start racking up convictions, life is hard enough as a Black young man in society today as it is. And when you start racking up convictions, it only makes the life more difficult for you. That's hard enough as it is. And you're not getting it through. If I go drug test you now, what is the result? Even after months of me preaching to you not to use. I don't want you to answer the question. What I'm trying to break through to you is that I have repeatedly told you not to use. I've told you not to hang with dogs because you're going to get fleas, and not you caught yourself a damn flea. I don't know what to tell you, but here in court, we have resources, right? If you want resources, we're happy to give it to you. We had a kid in here yesterday, giving him resources to get a phone and a tablet. If you want a place to stay, we can find you a place to stay. If you want something to eat, we can get you something to eat. But how on earth can I continue to let you go when, number one, you don't come to court? Number two, you continue to go to the place we tell you not to go. Number three, you continue to pick up cases when we tell you not to, over a damn case of beer and a large pack of candy. Mr. Lestrade, they know you at that Walgreens. Every single time you go back to that Walgreens, you have about every single eye in the sky looking at you every 15 ways from Sunday, watching your every move.
Yes, sir.
Ray, I'm sorry. I'm not going to give another PR bump. You know, perhaps, I don't know, but you're not getting it.
Can we at least address the bond, though, Judge? Because I believe the bond's at
Absolutely happy to. I agree that they're high. And what do you think?
Judge, I'd be asking for 500 on each case.
Okay, done. But the revolving door closes today.
Yes, sir.
It goes with you.
Judge, did you already talk to him about his non-driving affidavit and all that?
That's what
Just go over there and sign your bond.
I told him that he can't drive.
Yeah, I know.
We're nearly 120 miles an hour weaving in and out of traffic.
No, I got you.
I just came back from work, like I had to get half a day, how much could you go back?
My only condition,
Could there be like a curfew or something, or like anything like that? Cause I have to.
nearly 120 miles an hour in and out of traffic.
I'll talk to you in a second.
Sir, you were charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On January 5th, 2025, the officer was conducting surveillance as part of a traffic crimes task force of motor vehicles racing westbound on Grand Parkway, and the officer observed the defendant's vehicle traveling in lane 2 and another vehicle in lane 1. The motor vehicle slowed down to approximately 30 miles per hour before launching at the same time in a competitive manner, accelerating to well over 110 to 125 miles per hour in attempt to outpace each other. The motor vehicles raced 3 times, then pulled into a Buc-ee's. The officer observed the defendant but was unable to locate the other motor vehicle involved in the race.
So then it says also he picked up a felony evading he was on bond for a felony evading and now he's picked up this case, a racing?
It looks like that's the case, Your Honor. He was on bond for the evading.
I'm taking away your privilege to drive. You are not allowed to drive, Mr. Lee. Do you understand? You will be signing an affidavit with me today promising me you're not going to drive. I don't give a rat's behind what is going on in your life. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. This is an affidavit that you're going to promise me that you're not going to drive. Do you understand? There's a burning building with 50 kids in it. I don't care. Do not drive. You are Joaquin Hernandez.
Sir.
Mr. Hernandez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 12th, 2025, the officer was dispatched to 7000 Gulf Freeway, and another officer had advised that the defendant would sleep in the driver's seat of the vehicle. The vehicle was on and running, and the officer observed a container of beer in plain view in the center cup holder. The officer made contact with the defendant.
Drinking while driving?
Yes, Judge. And the officer observed a strong odor of an alcoholic beverage, watery bloodshot eyes, slurred speech, and the defendant admitted to consuming beer, but did not state the amount. The officer observed a 12-ounce Michelob Ultra cold to the touch and a plastic bag labeled Margarita to go with a straw sticking out of it, mostly consumed, and an open pack of beer in the back seat. The standard field sobriety tests were performed. HGN 6 out of 6. Walk and turn and one leg stand were not performed due to the defendant claiming he had one bad leg. The defendant was read the DIC and declined to provide a sample, and a blood search warrant was signed and executed.
Mr. Hernandez, I'm going to find that there's probable cause to go forward with your case. Can you see if he has any prior DWIs, please?
Yes, Judge. I see no prior DWIs.
I would venture a guess that it's damn elementary that you're not supposed to have alcohol in the car. I am now taking away your privilege to drive. You will be signing an affidavit with me today promising that you're not going to drive, and I don't give a rat's behind what is going on in your life. If I find that you drive, and I don't care if there's a burning building and you have to save 50 children, I can have a contempt hearing. And every time you drive, you can be facing up to 6 months in jail and a $500 fine. Do you understand? Do not drive for any reason. You are Samuel Escobedo.
Sir.
Sir, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On January 26, 2025, at approximately 12:31 a.m., the officer observed the vehicle on East Sam Houston Parkway turn southbound in front of the officer, making a wide right turn and entering his lane of travel, forcing him to slow to avoid a potential collision. The officer observed the vehicle swaying within its lane and within the vicinity of another motorist. The vehicle accelerated to a high rate of speed of 61 miles per hour in a 45-mile-per-hour zone, and a traffic stop was then initiated. The officer made contact with the defendant and observed glossy eyes, slurred speech, and odor of an alcoholic beverage. The defendant stated he was coming from a party where he had 2 shots and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 3 out of 8, one leg stand 2 out of 4. The DIC was read and the defendant refused to provide a breath specimen, and an inventory search was conducted, and the officer found 2 Modelo's cold to the touch and mostly empty, and 1 pint of vodka. The passenger advised the vodka was hers and the beers were the defendant's. Blood search warrant was signed and executed.
Drinking while driving?
Yes, Judge, cold to the touch.
Mr. Escobedo, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm now also ordering you not to drive at all. Do you understand?
Sir.
You will be signing an affidavit with me today promising you're not going to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car and drive. I don't care what your excuse is. Do you understand?
Sir.
I would think that it's elementary that you're not to have alcohol in the car while you are driving. If I find that you pick up a new case, you become a danger to my city, you consume alcohol or you drive, I will revoke your bond, put you in jail, no more PR bonds for you. Do you understand?
Your Honor, for my client. My client is 19 years old, Your Honor. I've known him for a long time. I know his family, and he works at the refineries right now. It would be onerous on him to not be able to drive. And Your Honor, my client would be requesting if maybe there was some alternative, potentially a machine in the car to make sure that he's.
You know, I mean, he's 19. There's alleged 2 cold beers he's drinking while he's driving. No, I want you to appreciate the absolute privilege it is to drive. It's not a right. You want to right, take your Dutch patas and you can do that. No. If after a while you can show me that he appreciates it proactively, right? And I get it, then we can talk. But until that point, I don't care what you're doing. I don't care if there's a burning building, you have to save 50 children. You drive. It's really not going to go well for you. Do you understand? Mr. Ellis, let me read something to you. This is why the magistrate did not give you a PR bond in this case. Defendant on a 3-year deferred for a state jail felony since 3/21/24 allegedly stole CBD disposables. In this case, the witness called to report a man dancing around and waving a firearm in the air at the 5900 Long Drive in Houston, Texas. Law enforcement officers arrived, saw defendant matching the description as sitting at a bus stop, saw butt of gun sticking out of his pocket. Law enforcement officers told defendant to put his hands up. Defendant instead reached for his gun. Do you know how many people die from that very thing right there? Watch the news every single day in America. A young person dies just because of that very thing right there. Law enforcement officers struggled with the defendant as he continued to reach for the firearm, finally got him cuffed after approximately 6 minutes, then recovered a loaded .45 pistol from his pocket. One law enforcement officer injured during the struggle, pushed against the wall of the bus stop, sustained minor abrasions. Could have been another assault of a peace officer, which is a 3rd-degree felony, 2 to 10 in the penitentiary right there.